Any mention?
Wait, please, my lord. I beg to mention item 41. Item 41, my lord.
No objection.
My lord, the conducting counsel, Ms. Ain, is indisposed. She'll be here by the 12th of August.
After 3 weeks, yes.
Obliged, my lord.
May it please your lordship. Lordship, I beg to make a mention of item number 31, your lordship.
Number?
31, your lordship.
31.
Yes, your lordship. 31 to 33 are connected, your lordship.
Okay.
As the learned DSGI is on
31
sanction.
and?
31 to 33, your lordship.
31 to 33.
Yes, your
But
lordship.
there are orders matter also in this case. And where lordship has directed a state to take instruction, which we have it. And senior counsel will be here, my lord. So this matter can be kept, my lord.
Which
Item
senior
12
counsel?
to 22 in the orders column, my lord. So we have received certain instructions.
Item number?
12 to 22 in the order list.
Is
my
the acquisition matters?
Land
My lord,
acquisition
yes,
matter,
IDF
madam. Pending for
12 to?
12 to 22.
Let me call out. Doesn't
My
matter.
lord.
Yes, yes.
We'll adjourn it later, yes. The hearing matters. Yes.
My lord, I beg to mention item number 37.
Yes.
My lord, on behalf of the state respondents, my lord, I Lingwa, my lord. My lord, here the FSL report is awaited, my lord. So I'm praying for some more
What's the
time.
matter about?
It's about alleged drowning, Your Worship.
About or the drowning?
Alleged drowning, yes.
FSL report?
My lord, I have been informed that FSL report is yet to be received, so I'm praying for further time.
FSL report on what?
My lord, I have only, Miss Ailingwa is in bereavement. That is the only information she could give me on the phone. Miss Ailingwa is on the bereavement, my lord. That is a short instruction she could give me on the phone. We can have it after 1 week, my lord. Hopefully she'll be
2
joining.
weeks, yes.
Highly obliged.
Last time said the phone I was handed over to the...
My lord, yes. I believe that is the one that has been sent
Yes.
for FSL.
Lordship, I beg to make a mention of item number 36, your lordship.
Yes.
I pray this matter may be listed after 2 weeks, your lordship. Similar prayer for item number...
For the petitioner. Mr.
Consent
Guru.
has been already sought, your lordship. Consent has been already sought, your lordship. Similar prayer for item number 43, your lordship.
36 and 43.
36 and 43, your lordship.
Yes. After 3 weeks, yes. 43.
Highly
yes.
obliged, your lordship.
May I please, your lordship?
44, not necessary.
I beg to mention item 45 and 46, your lordship.
45,
They are
46.
connected matters, your lordship.
Why? Who's
I have no objections.
Your lordship, the conducting counsel is out of station, your lordship.
Who's the conducting counsel?
RS Nanyang.
Yes, 2 weeks, yes.
Obliged, your lordship.
Your Lordship, I will mention item 39 and 40. Connected matter, Your Lordship. Only pray for 1 week time, Your Lordship.
Why are you praying for time? Same matters. Okay, 39, 40 after 4 weeks, yes.
Will be obliged, Your Lordship.
We'll get long adjournments now. Since asking the time, then some cases are being adjourned repeatedly. So we'll adjourn them for sufficient time for you all to prepare, yes?
Your Lordship, I beg to mention item 42 on behalf of 3, 4 and 5.
42?
42, Your Lordship.
Who's the
Your Lordship, I
petitioner?
pray. No objection, Your Lordship. Your Lordship, I pray for some accommodation between the 5th of August and 19th of August.
No time, no dates can be given. 2 weeks, yes. You take the dates from the court master. Because there's no point fixing dates. When dates are given, the court reads the file, and the moment the court sits is adjourned.
I beg to
Yes.
mention item number 35, lordship.
35.
Yes, lordship. Due to
This matters to be heard finally, I think, regarding the construction
My lord.
on the road.
Instruction is not yet, lordship. Up to 1 week, lordship.
Who's not there?
Sorry, sir. Instruction is not there. Up to 1 week, lordship.
Okay, take 2 weeks, yes.
Similar prayer from for this item number 38, lordship.
38. Why you want to do this matter?
Due to personal difficulties, lordship.
Okay, 3 weeks, yes.
Highly blessed, lordship.
Now give very long adjournments. There's no point crowding the rest.
Wait, please, Your Lordship. Your Lordship, I beg to mention after 2 weeks, Your Lordship.
You for the respondent, where's petitioner?
I vote a petitioner, Lordship.
1 week.
Highly obliged.
Highly obliged. My lord, item number 48, I am for the state. In fact, item number 48, I am for the state. The counsel for that petitioner, that N.I. Chaudhary lordship, he went for medication, Hyderabad
For?
lordship. 48 lordship.
He went for what?
I am for the state lordship.
So he went for what, Mr. Chaudhary?
N.I. Chaudhary is for the petitioner lordship. So he personally morning called me, he went for medication, Hyderabad lordship.
For medication?
Yes.
Medical treatment.
Meditation or medication?
Medical
What?
treatment lordship.
Medical treatment, say that. Is it medication or what? Yes.
Medical treatment.
After 3 weeks, yes.
Item number 1.
Please, Your Lordship. Lordship, this writ petition is against the
Yes.
against the selection process of respondent number 5, my lord, to the post of assistant teacher, my lord. Assistant teacher RMS in Rajabala Higher Secondary School, man. My lord, the facts,
Why do you say why is challenging appointment? On what ground?
my lord, he was one of the candidate, my lord, who had applied for the post.
The petitioner.
Yes, my lord. And what had happened is, my lord, though the advertisement was floated in the year, my lord, published in the year 2023, my lord, the scheduled interview was scheduled on 9th. And I received the intimation only on 8th. My lord, that was done purely to pave way for the appointment of respondent number 5.
8 means they published the notice on 8, then
No.
interview on 9.
No, what happened, my lord, the advertisement was published in the year 2023. So there were ample time for them to intimate me by way of a call letter, in physical call letter. What they did, my lord, they did not do any of such things. What they did, my lord, a day, they fixed the interview date, which I was oblivious of, my lord. They fixed the interview date on 9th. And they sent me a call letter via WhatsApp, my lord, on 8th. And that was done purely to pave way for the appointment of respondent number 5. And my lord, on 8th, I could not appear obviously on the next date, my lord, because on 8th I was traveling from one place to another. Your lordship will see my tickets are next at page 27.
Traveling from?
From Haj Singamani to Kuch Bihar, West Bengal. I was in Siliguri that point of time.
There's a bus ticket?
Bus ticket, my lord. And not only that, my lord, this was done on the face of a review petition being pending to the, pending where, my lord, this same post, my lord, is a subject of.
Yes.
And this was done at the fag end of the term, my lord. Their term is set to expire after 3 months' time, and they did all this. Managing committee, my lord.
My lord, that is not true, what my friend is saying.
Yes.
What had happened, my lord, in the writ petition, my lord, there was a writ petition before the Honorable single bench of this Honorable Court, my lord. That was WPC number 114 of 2015, my lord. Now, my lord, that was disposed last 2015, my lord. So, my lord, here, my lord, what had happened? So, there, my lord, I was the counsel for the petitioner. We had challenged, my lord, in that case, my lord, we had challenged the whole selection process, my lord. And that was subsequently quashed by the Honorable Court, my lord, finding all sorts of illegalities. Now, what had happened thereafter, my lord? The private respondent number 9, in fact, my lord, she had participated in the selection process. Thereafter, my lord, she perhaps realized that she did not fare well.
8?
That in that case, my lord, it was Miss Jasmine Jahir, my lord.
This is a different person altogether.
No, my lord. What had happened?
There is no conflict of interest. You appearing for the state here. In the other matter, you appear
No,
for
my lord, because
petitioner.
that matter is over, my lord.
Even then, if he is connected, then why are you citing that case?
My lord, he's appearing for a private
So, my lord,
respondent.
if that is so, my lord,
Even
my friend
before
was
the review petition.
my friend was appearing for that candidate, my lord.
There's
in
no
that
bar.
case.
There's no bar, my lord. For me
So
to
if that
appear
is the case, my lord, my
Or
friend was
different
appearing for
candidate.
that
We don't
candidate,
want to go there.
and he was.
I mean, whatever you have your, we don't understand. Now he's come as a fresh. He's a fresh
No.
person.
Fresh
fresh
person.
person, my lord. He's a fresh person.
Now here, my lord, some instructions I have received, my lord. What I was informed is that this person, on purpose, he did not appear, my lord. Otherwise, clear intimations were given to him, and a person
Okay,
was.
then you file affidavit. if clear intimation is given, then if he has no case, if it's got prior notice, then.
My lord.
But if there's some. Anyway.
So in such cases, normally a call letter is sent, my lord. Here.
No, I heard Mr. S. Thapal, counsel for the petitioner, if you notice, Mr. G is present, accepts notice on behalf of the respondents number 1 to 3. Notice to go to number 4 and 5 within 3 days by Ms. AD.
Well, I'm praying for some kind of an interim. Only why I'm saying this, my lord, because if the appointment is made, my lord, my entire reputation will become in fractures. No, my lord, it is still pending for approval. Let the status quo be.
Petitioner shall be subject to resolve petitions.
Item number 2.
Any appointment made shall be subject to that petition. Yes.
May I please, Your Lordship? Your Lordship, in this matter, I humbly pray 2 weeks' time, Your Lordship, to file the affidavit.
What's the matter about?
This is regarding their salary, Your Lordship.
This is actually the payment of their allowance, gratuity, and other areas.
Of the husband?
No, not husband. She has gone already retired. Yes.
Okay. Same problem they have. They don't have money. So we have to wait. Further 3 weeks' time granted for affidavit. As per it is.
Item number 3.
May I please, Your Lordship, in this matter, the respondent 6 is supposed to file the affidavit, Your Lordship.
Who's number 6? This is regarding
Selection process, Your Lordship. Selection
regarding?
process.
This is regarding appointment, Your
Oh,
Lordship,
the
of the
UGC
new.
care.
Yes, Your Lordship.
Yes. Who has number 6? MS, who paid B. Karavan Lang last time? Let's go ex parte against them. Number 6.
Yes, Your Lordship.
Let's go ex parte against respondent number 6.
They are necessary party also, Your Lordship.
Then where are they?
Time and again, Your Lordship.
Thapa was here just now.
Because time and again they have asked time to
How
file
many
the
times they
affidavits.
played? Yes. 5 and 6. 6 is whom? Selected candidate. Yes, take
Yes,
down.
Your Lordship, in
They have filed affidavits. You filed it,
Yeah,
right? Affidavits on behalf of response 1 to 4. That's already on board. As respondent number 6, don't want to stop. There's no representation on behalf of number 6. Stop. It is noted that repeated time has been sought for filing of affidavit on behalf of respondent number 6. As there is no appearance and no further premier, filing affidavit is closed.
Your Lordship, hearing on behalf of respondent number
You not filed it? Yes? Yes.
And we'll file the affidavit.
You're for whom?
Respondent number 7, P. Agarwal.
You just
Oh, yeah, that's all right. That's already there.
Much better.
Not recorded in the early order.
Item number 4.
May I please, Your Lordship? Respondent number 7 state has already filed a counter, my lord, and will not be filing any rejoinder.
Who?
Respondent
Now
7.
you file counters immediately.
My lord, yes.
How come?
My lord, we had a meeting with the department, so with the cooperation we were able to file, my lord.
Very strange.
No, my lord,
Well,
there are
affidavit.
multiple departments here, my lord. So the answering respondent appears to be the water resource department. And all the documents which they have provided us, it's not in contradiction with the petitioner, my lord. So it has been confirmed. So, my lord.
It is not?
So, my lord, we have confirmed that all the documents which are attached in the petition, my lord, are true, my lord. And we have already prepared the estimation also, my lord, as per...
And given to the
NHIDCL.
Who's
my
appearing
lord.
for NHIDCL?
Mr. Depnath, my lord, on the last occasion.
Was Mr. Depnath doing sleeping? Where is he?
This matter may be posted for admission hearing, my lord.
Yes. An affidavit has been filed on behalf of respondent number 7. Stop. This is matter of admission hearing after 1 week. Yes.
Right.
None has. What, Mr. Devnath? There is no representation behind respondent number 2. Yes.
Item number 5.
Yes.
May I please, Your Lordship, I would like to withdraw this matter, Your Lordship, with liberty to challenge this order, Your Lordship.
Yes, Ms. N. Raji, please be allowed to withdraw the instant petition with liberty to challenge the order. To challenge the order, disposing of requisition dated
25th July 2023.
25th July
2023.
25th July?
25th July 2023, Your Lordship.
Okay.
Item number 6.
Stands closed on withdrawal. Yes, please. Yes.
Madam, can you grant one last opportunity? Due to personal difficulty, I couldn't file the counter.
Yes, further 3 weeks' time as prayed, allowed for affidavits.
7.
Mr. Devnath, I think this is.
I was in division.
You can submit from here, not from the door. Yes. 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 Where's affidavit?
Not yet, Your Lordship.
What about it?
3 weeks, Your Lordship.
3 weeks time is prayed, yes.
8.
Not here, I'm awaiting instructions. So I'll pray for 3 weeks.
Your Lordship, I'm praying for respondent 5. I'll pray for 2 weeks time.
Two weeks time is prayer. Next time will be different. Yes, 2 weeks time is prayer. We have respondents number 1 to 4, Kirpi and Parachaji and Lansang Luya for 5 years. 5, correct?
Yes, Your Lordship.
Item number 9.
Nine, 10, 11 are connected matters, my lord.
Yes.
Sorry.
Yes, where's Mr.
Also here.
My lord, I'm paying for the sole respondent.
Yes.
So, my lord, Mr. Jindal has made the statement, my lord. And in view of the statement that the
Yes,
matter...
Mr. Thapa, whatever we have, whatever submissions you make for the commission, when the matter is taken up again afresh.
My lord, in that event, I may be given some time, my lord.
No time. We've given enough time.
Why, my lord? I think, my lord.
Forms of personal difficulty.
My lord, here, problem today, my lord. My lord, may kindly hear me first. This has already been informed to my senior here. Today, my lord, the matter won't be taken because Mr. Paul's mother's health is not well. Because of that, my lord, otherwise he would have been here, my lord. This has been informed to.
See, there's nothing here in the matter. If the only thing is that you're seeking to, take a, benefit of an order that's been passed, which has been challenged, and which the commission says that it's on the face of the record the order is invalid. Correct. It's signed by one member, but then Mr. Paul said no, it's not so, and that it is valid in many ways. But then if the matter can be sent back, there was a problem.
That's what I'm saying. If
As if the order
Lordship can give me a day's time, my lord, I'll seek instruction.
Tomorrow.
Or else.
Yes, on the day, Mr. S. Thapa, on behalf of the K Police matter tomorrow. Interim orders continue until further orders. Yes.
Item number 12.
May it pleases your Lordship. Lordship, I have the instruction, your Lordship. If Lordship kindly have a look at that, sir, Your Lordship. I should copy it. Lordship, that remarks regarding the report of the joint. Lordship, I'm sorry, Your Lordship.
Yes.
So, Your Lordship, now it's for the you take a call on that, Your Lordship.
We'll close it.
Exactly. And Lordship, kindly see Lordship order passed on 29 February. Lordship directed the Union of the India to file the affidavit to close the matter. Lordship, kindly see the order. Lordship, as I appreciate, the matter is pending for quite a long time and delaying the matter.
No, now it's the final stage.
Yes, we should let them file an affidavit as a last chance when will be given to them and let them be processed.
Instructions as received by the learned AAG, Mr. N.D. Shulai, has been placed before the court today. Stop. Address to, yes. From the written instructions, a communication dated 22nd July 2024, which has been placed before the court, shows that the summary of land acquisition in respect of South Garo Hills, West Garo Hills, and Southwest Garo Hills has since been made by the concerned deputy commissioners, and the same has also been submitted to the Ministry of Home Affairs.
Lordship, by the department.
By the department
Lordship,
on
yes.
by white letter
Lordship.
dated 27 May 2024. Next one. In view of these developments, the number 528 1415, representing the union. Or you're representing whom? In the union, like to file affidavit so as to apprise the court of the status. Only in May, by the time they place funds, is 100 crores. A huge amount.
Huge amount.
It's,
kilometers of land they have taken away.
See, if one's 50 is one, see, 51 crores 98 lakhs. Other one's 43 crores.
It will cross, Your Lordship, more than 100 crores.
30 crores 26 lakhs.
That was also assessment made prior to 7 years ago, in fact. Therefore, pendency of the matter has a serious impact on the public fund. The department should not delay the matter.
No, the entire stretch, the company has not been paid. So, yes, over 100 crores. Anyway, no?
Lordship, my appearance may be recorded for
yes.
respondent.
Mr. Paske is present.
Lordship, item 12 to 22, then 31, 32, 33, Your Lordship.
Respondents, NHIDCL.
Same order will follow in the other item, Your Lordship.
You find, because then after that, before the court, you won't have any more. You'll have to pursue your own remedies.
Yes.
Obliged, Your Lordship.
Hearing item 23.
So, Mr. Jindal, why don't you apply your same formula here also? With the state government.
Possible.
You know that, Mr. Sen, Mr. Jindal facilitated the settlement of 144 land acquisition cases in Jayante Hills, which are pending for 22 years.
And these are also pending for 21 years,
Yes,
almost at the same
wait
time.
till 22 years.
22 years.
They were pending 22 years. So facilitated the. He was appearing for the requiring agency.
ONGC.
No, for INDIPCO, and he convinced them to increase it by, the settlement by 100%.
Lordship.
Last date was when?
Well, this is on the 11th.
Yes, that was you're still replying?
Short reply, my lords, because there are certain issues that have come up. Certain case laws have been referred to. I would like to just distinguish those case laws. And just on cost and some other issues, I'll place some judgments, my lord. I'll try and be very brief. The one submission which was made by my learned senior was on the question of that maintainability, although lordships have expressed their mind about the issue of maintainability, but there was an issue which affects the question of law. That issue was that it was the duty of the collector to make individual references after having received the joint application under section 18. Well, that cannot be accepted because there is no basis for that. There is no precedent for that. There was only a singular application, so that therefore the collector took that and sent it to the court. It can't be said that it was incumbent upon the collector to bifurcate them into individual reference applications.
That was not made by me.
I recall that because I had gone through the video again just to make sure I noted down all the points correctly. So that is one aspect, my lord. And lordships will see that the entire exercise of drawing up these individual decrees and by working out these incorrect calculations were not necessary in view of section 26 of the Act, which provides it's a deemed decree. So the award of the court itself was a deemed decree capable of being executed. Then another contentious point, well, is the issue of jurisdiction. I had placed reliance on a judgment of 2003.
Jurisdiction meaning?
That the collector, that the court, the special court, is vested with jurisdiction on the basis of the reference order. The terms of the reference bring the counters of the collector's jurisdiction over the matter. So I'd refer to a judgment of 2003 5 SCC 561. This is Prayag Upnivesh, if lordships will recall, where it had been held that unless and until a specific matter is referred to the court would not have jurisdiction over the matter. 2003 5 SCC 561.
Already referred
Already referred.
by you.
Yes.
Yes, yes.
Five SCC.
5.
Absolutely.
So kindly have page 565.
565.
Para 7.
Short judgment.
My lord.
What about that was placed by Ms. Jindal also the same judgment.
Yes,
right?
I'll just distinguish
so that. The court only on the point of reference has jurisdiction to enter into the.
Yes. So
right?
this was the judgment that I placed, which points out that the jurisdiction of the reference court will be determined by the reference order.
Yes.
So if certain matters are not referred to the court would not have jurisdiction over the matter. Similarly, parties have not filed an application under Section 18. The collector cannot suo motu send them for reference. The court would not be invested with that jurisdiction. So this is what this lays down. Lord. Can you have para 7 onwards? It is well established that the reference court gets jurisdiction only if the matter is referred to it under Section 18 or 30 of the Act by the land acquisition officer, and that the civil court has got the jurisdiction and authority only to decide. The reference court cannot widen the scope of its jurisdiction or decide matters which are not referred to it. This question was considered by various judicial authorities, and one of the earliest decisions reported on this point is so-and-so. This was a case where the claimant sought a reference under Section 18 of the Act. In the application filed by the claimant, he raised objection only regarding the valuation of the land. The claimant did not dispute the measurement of the land given in the award. Both the reference court, the claimant raised objections regarding the measurements of the land and sought for fresh measurements. This was refused and claimant applied to the High Court for revision of this order, but without success. Again in the appeal, the claimant raised the same objection regarding measurements and the High Court rejected it. The Judicial Committee of the Privy Council held thus: their lordships have no doubt that the jurisdiction of the courts under this Act is a special one and is strictly limited by the terms of these sections. It only arises when a specific objection has been taken to the collector's award, and it is confined to a consideration of that objections. Once, therefore, it is ascertained that the only objection taken is to the amount of compensation, that alone is the matter referred, and the court has no power to determine or consider anything beyond it. I'll just take your lordships then to para 9.
Yes.
In so-and-so, the land acquisition officer made a reference under Section 30 for the apportionment of the compensation amount amongst the various claimants. 6 of the appellants did not accept the award of the land acquisition officer and made application to him for referring the matter for determination by the court, but no reference was made by him pursuant to this application. When the matter came up before the court, it proceeded on the footing that the reference made to it was limited to the apportionment of compensation, but also with respect to the amount of compensation. No objection, however, was raised by the state before the reference court regarding the absence of reference. When the matter came before the Honourable High Court, the government pleader raised this objection, though the High Court allowed the plea to be raised before it, but ultimately it negatived this plea. The appellants contended before the High Court that pursuant to the failure of the state to raise the plea before the subordinate judge, as to the absence of a reference, the state must be deemed to have waived the point. Rejecting this contention, this court held, the matter goes to the court only upon reference made by the collector. It is only after such a reference is made that the court is empowered to determine the objections made by the claimants. Such a reference would certainly not invest the court with jurisdiction to consider a matter not directly connected with it. This is really not a mere technicality, as pointed out by the Privy Council in so-and-so. Wherever jurisdiction is given by a statute, and such jurisdiction is only given upon certain specified terms contained therein, it is a universal principle that those terms should be complied with in order to create and raise the jurisdiction. And if they are not complied with, the jurisdiction does not arise. This was therefore a matter of lack of inherent jurisdiction, and the failure of the state to object to the proceedings before the court on the ground of an absence of reference, insofar as the determination of compensation was concerned, cannot amount to waiver or acquiescence. Indeed, when there is an absence of inherent jurisdiction, the defect cannot be waived, nor can be cured by acquiescence. In a recent decision in the court of so-and-so, it was held that the reference court has no power to convert the reference under Section 30 into one under Section 18 of the Act at the instance of those who did not apply for reference. In the instant case, there was no reference by the SLAO under Section 18 of the Act, and the appellant Samiti was not before the SLAO. Even the application allegedly filed on so-and-so was rightly been characterized as suspicious, as no mention has been made by the SLAO in the reference letter dated so-and-so. In the absence of a proper reference, the additional district judge had no jurisdiction to decide the question of enhancement of compensation. When such an objection was not referred to the court, there was a complete lack of jurisdiction. Now, in response...
Now, this case regarding 18 and 30 reference.
Yes, my lord.
18, 30 are totally different.
No, but this is also regarding Section 18, my lords.
Yes.
Our case also relates to Section 18.
No, what are you saying?
On the question of what was referred.
The question of law, that if
Yes.
not referred, can be looked into.
Yes, my lord. So, in counter...
So, in their case now, just one application signed by 64 people, right?
More than that, 137 people.
137
137
people. So, you mean to say that since there's no specific reference made
So certain issues were not raised.
Made by these claimants. That means not incumbent upon the collector to make to.
Absolutely. And I'll distinguish the
general reference been given to the court.
So whatever has been
court
raised,
also be a general thing to make a belting method and finish it off.
No. What I'm saying, number one, we are on the first question of the reference.
So you're coming back to the root of the matter now.
Yes. If your lordships look at the Section 18 reference application, there are only certain things which have been mentioned there. One is measurement. The other is compensation. A passing mention has been made with regard to horticulture. The losses suffered for that. Buildings have not been mentioned. Your lordships can see that from the prayer as well. Thereafter, the collector made a reference order and sent it to the court. In that reference order, he has identified only certain issues.
Yes.
So the jurisdiction will be vested on the basis of that. Now, it is my learned senior's case.
The reference court can't travel beyond that.
Cannot travel beyond it. Now, rightly, wrongly, the collector has done whatever he had to do. Now, they are castigating what the collector has done. And for that, they've referred to two judgments. I'll just take your lordships through that. Kindly have the first one. This is the Calcutta Weekly Notes judgment, my lord, if your lordships recall. The one from 1907. This is 1907 SCC Online, Calcutta 69. But in this, the paragraphs are not numbered. I believe the fourth paragraph, it begins with, it is generally necessary.
Yes.
This is what was relied upon by my learned senior.
Yes.
May I read, my lord?
Yes.
It is generally necessary to take two or all of these methods of valuation in order to arrive at a fairly correct valuation. Exact valuation is practically impossible. The approximate market value is all that can be aimed at. Now, the ordinary rule of onus probandi in these cases is that the claimant, who is a plaintiff, must prove that the valuation made by the collector is insufficient. Now, kindly see the next part. The theory is that the collector, in arriving at his award, performs administrative and quasi-judicial functions.
Where is he from?
Well, this is the fourth paragraph in that judgment. It begins with, it is generally necessary to take
two all these methods, yes.
And
Exact valuation is practically impossible. Much reliance can be placed on evidence experts.
Well, the next paragraph would be now, it begins with now the ordinary rule of onus probandi. If I may just assist your lordships with that. In these cases, is that the claimant, who is a plaintiff, must prove that the valuation made by the claimant in the court of the special judge, but the burden may vary according to the nature of the inquiry made by the collector. If no evidence has been taken by the collector and if no reasons have been given in his decision to support his conclusion, the claimant has a very light burden to discharge. The mere ipse dixit of a collector has very little weight and is not prima facie evidence of the correctness of his award. Now, this is what was referred to by my learned senior and stressed upon with regard to Section 19 of the Act, where the collector makes a reference order. So it says here, instances are not uncommon where the collector has not given the grounds on which the amount of compensation was determined by him, and the legal result of his failure to comply with the provisions of Section 19(1)(d) of the Act is to make it incumbent on the collector to justify before the special judge an award which is a mere brutum fulmen. Now, if your lordships kindly see paper book 1. Now, this is a case where they say they're dealing with a situation when the collector has not mentioned any grounds whatsoever.
Page?
This is at page 108.
Yes.
My lord. At page 108, this is the reference order. Kindly see serial number 8.
Yes.
This says grounds on which the amount of compensation was determined in the case of objection to the amount of compensation. So the collector is required to make this statement.
Yes.
Which would be sufficient compliance of Section 19(d). So the collector has noted this. Amount of compensation was determined on the basis of the fair market value of land assessment. So it may not be palatable to the claimants, but the fact remains he has discharged his duty under Section 19D. Now the case of the Calcutta High Court, which was referred to, deals with a situation where no statement has been made for the purposes of 19D.
Yes.
So I would distinguish this part of the judgment. I would also submit, Manoj, very respectfully, that this judgment does not lay down good law as far as it speaks about the nature of the proceedings before the collector as well as the nature of the proceedings before the court. Because it says that the collector is performing a quasi-judicial function. And it also goes on to say that the special court discharges a function of a first appeal court. Now, this is not the correct view. The correct view has been laid down by a 3-judge bench of the Honorable Supreme Court. I had referred to this judgment earlier. I'll refer to it again. 2004 10 SCC 745.
Just give me the citation again.
2004 10 SCC 745.
And 10 SCC, right?
10 SCC. Kiran Tandon versus Allahabad Development Authority.
You seen it earlier?
Yes, my lord. At para 10, my lords, the 4th line from the bottom.
Yes. Letters 01 of section 11.
Are your lordships at para 10, my lord? No, from the bottom, the 4th line. It begins with the claimant is in the position.
Position, yes.
My lords.
Yes.
So this reads, the claimant is in the position of a plaintiff who has to show that the price offered for his land in the award is inadequate on the basis of the materials produced in the court. The material side will also have to be taken into account for this purpose. I apologize. I'll just read from the start, para 10 onwards, the entire paragraph. Before examining the merits of the contentions raised, it will be useful to bear in mind the legal principle in the matter of determination of compensation. The collector's award under Section 11 is nothing more than an offer of compensation made by the government to the claimants whose property is acquired. The burden of proving that the amount of compensation awarded by the collector is inadequate lies upon the claimant, and he is in the position of a plaintiff. Now, this is important, my lord. The court has to treat the reference as an original proceeding before it and determine the matter, the market value afresh on the basis of the material produced before it. The claimant is in the position of a plaintiff who has to show that the price offered for his land in the award is inadequate on the basis of the materials produced in the court. The material produced and proved by the other side will also be taken into account for this purpose. This is a judgment of a 3-judge bench which lays down that the proceedings are original in nature, and it also follows that the special court does not sit over the matter as a court of first appeal.
Yes. Yes.
The second judgment I'll rely on this point, Willows, is 2009-12 SCC 184.
2009
Yes. 12 SCC 184. SCC 184. The relevant paragraph is para 22 at page 190.
Yes.
This reads, the question whether the collector land acquisition officer, while making an inquiry and award under the Act, acts in a judicial capacity or not, has been considered in a series of judgments. The well-settled principles are: A. any inquiry as to the market value of the property and determination of amount is administrative and not judicial in nature. Even though the collector may have power to summon and enforce the attendance of witnesses and production of documents, in making an award or making a reference or serving a notice, the collector neither acts in a judicial nor quasi-judicial capacity, but purely in an administrative capacity, exercising statutory powers as an agent and representative of the government acquiring authority. The award by a collector is merely an offer of the amount mentioned as compensation on behalf of the government acquiring authority to the persons interested. It is neither an executable decree nor binds the owners or persons interested in the acquired property. The collector does not function as a judicial officer who is required to base his decision only on the material placed in the inquiry in the presence of parties, but functions as a valuer who ascertains the market value on material collected from all sources, personal inspection, and his own knowledge and experience. So this also lays down the nature of the proceedings before both these authorities. So this was to distinguish the statement of law laid down in the judgment of 1907.
What are the judgments?
As my learned senior also relied upon a judgment of 1991, 2 SCC 247, Ramkumar versus Union of India.
Which one is this?
1991, 2 SCC 247. So this dealt with the collector's duty to send correct and full information under section 19 to the special court. I'll just take your lordships to the short facts of this.
Yes.
From page 248, my lord. This appeal by special leave is directed against the judgment of Delhi High Court dated 10th August 1976 in civil revision number so-and-so. Agricultural land measuring 78 bighas and 14 biswas belonging to the appellant situated in the village Garhi Piran was acquired under the Land Acquisition Act. The Land Acquisition Collector passed an award on October 10, 1967 allowing compensation for land in Block A at 2300 per bigha and in Block B at 1200 per bigha. The claimant appellants submitted an application under section 18 of the Act for making a reference to the court. The collector made a reference to the court in pursuance to the said application submitted by the appellants. The additional district judge, by judgment dated 15 January 1971, increased the amount of compensation to 4,000 per bigha for the land in Block A and 2,500 per bigha for land in Block B. The appellants filed an application under sections 151, 153 CPC before the additional district judge, praying that the land in Khasras numbers 408 and so on had not been shown by the land acquisition collector in the statement made under section 19 of the Act, although he had sent the names of all the bhumidars of the aforesaid land. The mistake was on the part of the land acquisition collector, and the appellants should not suffer on account of the mistake or oversight of the collector. It was thus prayed that in the interest of justice, the collector may be directed to file a revised statement under section 19 of the Act, giving the details of the whole of the land belonging to the claimants, which had been left on account of the accidental slip or omission. The application was opposed on behalf of the Union of India. The additional district judge, after hearing the parties at length by order dated February 18, 1975, allowed the application and directed the land acquisition collector concerned to furnish the correct statement under section 19 of the Act regarding the land acquired of the appellants. So here was a case, my lord, where say about 10 plots were acquired, but while sending the reference order, only 8 plots were mentioned and maybe 2 were left out. So this was a case of an omission. So as soon as the claimants noticed this, they filed an application before the court asking for filing of a revised statement under section 19. That's very different from the case here. Here we have crossed that. We are long past that. Now we are at a stage of the first appeal. Can we say that a revised statement under section 19 should be filed? Completely different set of facts. So in this background, Lordships will also see what had happened. Kindly have para 3 then. We have heard learned counsel for the parties and have perused the record. There is no manner of dispute that the land acquired was 78 bhigas and 14 biswas and the appellants were entitled to the compensation of the entire land. The land acquisition collector gave an award and the appellants, being not satisfied with the amount of compensation, submitted an application for making a reference to the court under Section 18 of the Act. A perusal of the application submitted by the appellants under Section 18 of the Act shows that in para 1, it was claimant's land, details of which are given in the schedule, has been acquired under the aforesaid award. The collector has awarded a very low rate of compensation to which the claimants are not satisfied, as their claims have not been adequately considered by the collector. Thereafter, grounds of reference were stated in ground 9, which is relevant for our purposes, is reproduced as under: that the claimant petitioners claim compensation for the whole of their land at the rate of 20,000 per bhiga and 10,000 for the well and 200 each for each tree. They further claim 60,000 each for their resettlement, as their entire land in the village has been taken away under the acquisition and they have been uprooted. They also claim 15% solatium in interest at the rate of 6% per annum and the enhanced amount of compensation plus solatium with effect from March 4th, 1963. Now then kindly see para 5 at page 251.
Yes.
In our view, the High Court was totally wrong and unnecessarily complicated the matter, which seems to us quite simple. It is an admitted position that 78 bhigas and 14 bispas of land belonging to the appellants was acquired, and the land acquisition collector had given an award at 2300 per bhiga for block A and 1200 per bhiga for block B. The appellants were not satisfied with the above rate of compensation and they had moved an application for making a reference under Section 18 of the Act. In the application, it was clearly mentioned that the collector had awarded a very low rate of compensation to which the claimants were not satisfied. In ground 9, the claimants' petitioners had mentioned that they were claiming compensation for the whole of their land at 20,000 per bhiga. That apart, in the schedule also, some khasra numbers were mentioned specifically, but in the end, the words used were etc., etc. The additional district judge had passed the order on January 15, 1971, and immediately on the next day, that is January 16, 1971, the appellants had submitted the application under Section 151-153 CPC for correcting the mistake. The additional district judge, who was seized of the matter, allowed the said application by his order dated February 18, 1975. Thus, from a perusal of the application filed under Section 18 of the Act, along with the schedule, we are fully satisfied that the appellants were claiming an enhancement in the compensation in respect of the entire land acquired, and there was no question of asking for reference for a limited portion of the land measuring 34 bhigas and 2 biswas only. So in this background, this is what has been held. Kindly have page 252, the last paragraph. Under Section 18 of the Act, the only requirement for the person interested who had not accepted the award was to move a written application to the collector requiring the matter to be referred for the determination of the court. One of the grounds for not accepting the award was the amount of compensation. Once such application was moved, it was a duty of the collector to make a reference to the court. Under the reference, the collector was required to state for the information of the court the particulars as mentioned in clauses A to D of subsection 1 of section 19. Thus, it was the duty of the collector to mention not only the situation and extent of the land, but even particulars of any trees, buildings, or standing crops thereon. The agriculturist whose land is required may not be fully conversant with the khasra numbers or area as entered in the revenue records, and the Union of India or state acquiring such land should not be allowed to take advantage of such ignorance of the agriculturists. Once an application is moved for reference, for making a reference under Section 18 of the Act, it becomes the duty of the collector to send full information to the court regarding the entire land acquired, and it is thereafter the duty of the court to decide the matter in accordance with law. So, this was merely a case where certain plot numbers were omitted in the reference order. Very different from our case. Our case, they did not raise those particular grievances.
Yes.
So, factually, this is to be distinguished, my lord. So, instead of saying that it is the collector who is taking advantage of the wrong, this is quite the converse. It's a case where the claimants have deliberately omitted to make a mention of their grievances.
Can it apply for the ignorance of the claimants to raise these kind of disputes has resulted in them being deprived? Contra.
I understand that. But then we'll have to look at their application under Section 18. What is their actual grievance? In this case, it was just an omission of the khasra numbers, the plot numbers. And they also mentioned etc., etc. I want compensation for so-and-so plots, etc., etc. So they clearly pointed out what their grievance was. In our case, they have not raised certain grievances. So therefore, we come back to that first judgment which talks about the reference court's jurisdiction. If the matter has not been referred, the court would not have jurisdiction. Number two, in this judgment, the correction was made at a very early stage, my lord. From the facts Lordship will notice, they immediately went back to the court and requested for a revised statement under section 19. That's not the case here. So the fact remains that the Honorable Supreme Court upheld the course adopted by the special court in seeking a revised statement, because that revised statement will again invest jurisdiction on the court, not otherwise. There's another judgment that was referred to, 1968 SSC Online, Kerala 92.
1968. We're concluding today, right?
Yes, yes, ma'am. Yes, I'll.
Mr. Jindal, today over. You don't have any reply submissions.
Yes. No, there's nothing new, my lord, that I'm bringing.
No, that's what. No, you only distinguishing the
yes,
right?
Just summarize the thing and.
Yes.
So this is 1968 SCC Online, Kerala 92. This is again referred to by my learned senior.
Kerala 92.
Page 92, minutes. Para 8 and 9.
Too many judgments flying in this case.
Lordship, I was of the view, I'll make a compilation of the judgment that I'm referring to.
You have to somehow,
yes, yes.
Digest the whole judgments.
But that's the reason why I did not make it a compilation earlier, because I knew that the judgments would keep changing.
Compilation, it becomes a bit easy now.
So I'll make a compilation now.
What happens, some cases which we're handling, these judgments fly, they're given like this, 1, 2, 3, and sometimes, you lose track of them.
Lordship.
And the note you see, you made it, and you can't find it. Because we have this multiple keeping files, this system also.
In my compilation, it is there.
Is there?
Page number 119.
Page number?
119.
119 is 2008.
Sorry, sir. This is their judgment. This is their judgment.
So you have an extra copy?
No.
I'll just share a copy there. नहीं मैं ये दे I'll give mine.
It's not here in your compilation.
No, it's not there. This was referred to, I think, on the
referred by them, and I have given a list of book, and for me, I have made a compilation.
For your own judgments?
No, his judgment.
No.
For yourself, you compilation.
For me only.
No, this is a judgment that was referred to by my learned senior.
One compilation which I gave, that is judgment which I referred.
Yes.
He referred many judgments but gave loose sheet. I have compiled those things only for my reference.
Leaving the court to grapple here and there.
No, because these were his judgment. I don't know which.
No, I'll put a compilation together. I kindly have para 8.
In making reference to the court,
yes, my lord.
The collector completely ignored.
In making reference to the court, the collector completely ignored the provisions of section 19 of the Act. He made no statement furnishing the particulars required by subsection 1 of the section, objection having been taken to the amount of compensation in his award being what it is. It was most important that he should at least have stated the grounds on which he determined the compensation as required by clause D of subsection 4. Neither did he prepare and forward the schedule required by subsection 2. All he did was to send his records of the case with a covering letter called a reference letter, of which the letter in AS number so and so of 1963 may be set out as a sample. Sir, the records of the LA case number so-and-so on the file of this office are forwarded herewith under Section 18 of the LA Act. The 16 cents of land in SY number so-and-so of so-and-so village was taken possession of by the state on so-and-so for the COSA research farm. The amount awarded was paid to the defendant, that is the landowner. A copy of the award statement number 84 dated so-and-so showing the name of the defendant, the amount awarded, etc. is also enclosed. So here there was no statement under Section 19. That is what the court has recorded. It's very different from my case. In our case, there is a statement under Section 19.
There is no statement at all, you say?
Yes. So that's the case here. There was no statement whatsoever. And there was only a reference forwarding letter. That's it. Then, there was again some question about on whom does the burden lie for...
Now your argument is that burden will be on the claimants.
Yes.
Also, since it's like original court.
Yes, my lord.
And they come for the, so to, you know.
Yes, just to buttress it, there are three judgments, my lord.
The reference court is not just a string appeal.
Yes.
But then
it's a completely original proceeding.
But then the way it conducts itself is like an appellate court only. Because material is already there on record.
Lordship.
It's a question of materials being, you know, like the subjective satisfaction of the collector.
My lord. So
again, the subject satisfaction of then other evidence might be placed.
So that is one way to look at it. But if we actually read Kiran judgment, the judgment in Kiran Tandon, what that lays down is that it is an original proceeding before the special court,
because you can adduce
and the burden is entirely on the claimants. If they fail to discharge their initial burden, the proceedings have to end there. There is no reason for him to go any further. That's the case I'm trying to make out, my lords. Here what is being argued that now since they have failed to make out a case, the onus lies on us. And I'll take your lordships to some of the judgments that have been passed here. It's based on a completely wrong premise. If it lays down that the entire onus, the initial onus, is entirely on the claimant to establish before the court that the rates offered by the collector are not adequate, he has to prove it. If he fails to discharge that, the onus does not shift to the collector. That has not been held by any of the judgments. So that being the case, kindly see what happens. The court clearly records that they have failed to discharge that burden. Those three sale deeds are not acceptable to the court. They are not reliable. Matter ends right there.
Okay, then you mean, okay.
Matter would end right there.
What judgment are you referring to?
So the first 1994, 4 SCC 595. Same issue.
No, already
1994.
1994, 4 SCC 595. The relevant part is at page 601.
You over this one, para 8 and 9, finished. The no
Yes,
statement at all. You see, no statement under
the judgment of Kerala, my lord? Yes, yes.
Yes.
There was no statement at all, and the court has recorded that.
That means no reference as required by the Act.
So they
hold no amount to a reference as required by the Act.
Yes, yes.
That's what the judgment says, yes.
So there was a clear omission on the part of the collector.
Yes, this other judgment?
This is 1994, 4 SCC 595. The relevant paragraph is para 5 at page 601. At page 601, the 7th line from the bottom.
The burden of proof.
The burden of proof notes. The burden of proof is always on the claimant to prove in each case the prevailing market value as on the date of the notification published in the State Gazette under section 4(1) of the Act, with reference to the sale deeds of the same lands or neighbouring lands possessed of same or similar advantages and features executed between willing vendor and willing vendee or other relevant evidence in the reference court. The state did not file any appeal against the award of the reference court, which itself is a matter gone in favour of the appellant. We do not find any justification to further enhance the market value. The next judgment, my lord, is 1997, 9 SCC 673.
Yes.
The relevant page is at page 675, para 4. Para 4, at placetum D.
Yes.
Just towards the right hand side, neither the vendors nor the vendees.
Yes.
Says neither the vendors nor the vendees were examined as witnesses. Therefore, the rejection of those sale deeds is perfectly in accordance with law. They do not form any base for determination of the compensation. It is settled law that the burden is on the claimants to prove by adducing cogent, reliable, and acceptable evidence the market value under 23(1) of the Act. The burden does not shift over to the government, but it is a duty of the court to assess the evidence adduced by the claimants and determine the compensation on the touchstone of prudent purchaser in the open market. That is, whether he would offer market value at the rates proposed by the court. The evidence has to be put to the test whether sale deed or the evidence adduced would offer the market value higher than what has been determined by the land acquisition officer. The compensation awarded by the land acquisition officer is an offer that binds the government, but it is not conclusive. It is for the claimants to prove to what would be the reasonable compensation which the land is capable of fetching in the open market. The question is whether the land under acquisition is put to the private sale in an open market would be capable of securing the same price as offered by way of determination of compensation after compulsory acquisition. So again, this holds that the entire burden is on the claimants and it does not shift to the collector. The next one, my lord, is 2013.
You placed this earlier on.
No, I did not place it, my lord.
Yes.
Because my learned senior was arguing this point that the burden would shift to the collector. But in what situation? Here, if they have not discharged the initial burden, the burden would not shift. So next one is 2013-14 SCC 50.
2013
14 SCC, page 50.
Para?
It's para 7.
Same point.
Similar issue, my lord. At page 54, relevant page. Lordships have it.
We have heard learned counsel.
We have heard learned counsel for the parties at some length. It is tried that in a reference under Section 18 of the Land Acquisition Act, on the question of adequacy of compensation determined by the collector, the burden to prove the collector's award does not correctly determine the amount of compensation payable to the landowner is upon the owner concerned. It is for the claimant to prove that the amount awarded by the collector needs enhancement, and if so, to what extent. The claimant can do so by adducing evidence, whether oral or documentary, which the reference court would evaluate having regard to the provisions of Section 23 and 24 of the Land Acquisition Act while determining the compensation payable to the owners. To that extent, the claimant is in a position of a plaintiff before the court in the absence of any evidence to prove that the amount of award by the collector does not represent the true market value of the property as on date of the preliminary notification. The reference court will be helpless and will not be justified in granting any enhancement. The court cannot go by surmises and conjectures while answering the reference, nor can it assume the role of an appellate court and enhance the amount awarded by reappraising the material that was collected and considered by the collector. Now, this is a very relevant judgment, my lord. So it says the court's hands are tied at that point. If the claimants fail to discharge the burden, the matter would end right there. Now, point out, my lords, that the special court in this case had applied a methodology for granting parity which cannot be countenanced by any known settled principle of law. So what would happen if the court does grant any kind of enhancement which is not in consonance with the known or the settled principles of a determination of market value? This is a judgment of 1995, 1 SCC 717. New judgment. Just 2 or 3 news. 1995, 1 SCC 717. The relevant paragraph is at page 721. Para 7, page 721. This reads, the reasonable method to determine the market value of the acquired land is on the evidence of transactions of bona fide sales of acquired land, but not on evidence of sales of such land got up having had knowledge of the proposed acquisition. The former would furnish reasonable basis to determine in its absence bona fide sales but not manipulated sales of the lands in the neighborhood possessed of same or similar quality and having the same or similar advantages would give an unerring assurance to the court to determine just and proper compensation. Such sales must only be proved but also be bona fide transactions, etc. These factors must be established as a fact by examining either the vendor or the vendee. Marking of certified copies of sale deeds are not proof of either the contents or the circumstances in which it came to be executed. Bona fide sales or series of sales of small pieces of land do not furnish the sole basis to determine market value. Bona fide sales may furnish evidence of the market conditions for consideration. Fixation of market value on the basis of the basic valuation register is therefore illegal and unsustainable. Then kindly see para 9 at page 723, the last line. For the said reasons. Para 9, it ends at page 723, the last line. For the said reasons.
Yes.
For the said reasons, determination of compensation is vitiated by application of wrong principles of law.
Okay, this is just circumstances of which,
Lordship. So what would be the result if the court applies incorrect principles?
What's a reasonable method?
Lordship.
To determine.
So again, this also lays down that simply marking of documents would not be sufficient.
Okay.
Then your Lordships will recall a submission was made with regard to the interpolations and the overwriting in the sale deeds. So my learned senior had suggested that on behalf of the collector, during the course of the cross-examination, no questions were put. Now the question is, on whom does this burden lie to satisfy the court as to the document? Now, usually when there is an interpolation, the parties who are the executants, they make a counter signature to indicate that they are aware of it. But if that's not done, what happens? This judgment lays down that it renders a document void. So this is 1991 SCC.
Give me a citation.
1991.
Yes.
SCC online. Madhya Pradesh 160. There's a relevant page is at page 392, para 14. Lordships have it, para 14. The common rule of burden of proof is that burden lies on the person who wants the document to be acted upon. It is the plaintiff who wants to take benefit out of this document, him to prove to the satisfaction of the court as to how and when the document was executed. Further, burden lies on him to prove the overwriting, overfiguring and alleged interpolation in the document. The plaintiff has completely failed to discharge this burden. Interpolation appears to be purposeful and therefore it has rendered the document void.
So the document is void.
Hello.
Interpolation.
This is only on account of the question of interpolation. Apart from other have argued that even legally they can't be recognized. But this is only just to meet that submission that we did not put any questions on the issue of interpolation. Then there's another very important issue that was raised on the question of cost.
Cost.
That the cost is automatic, and in case the special court does not grant it, then the claimants have a right to make that claim before the appellate court, and the appellate court will automatically grant the cost. So for that purpose, they had relied on a judgment of 1991, 1 SCC 262.
2 SCC or 1?
1991, 1 SCC.
262.
262. Shri Vijay Cotton. The relevant part that they'd refer to is at page 269. Page 269, para 15.
Yes.
This reads, we have carefully examined the reasoning of the High Court in reaching the conclusion which we have reproduced in the earlier part of the judgment. We do not agree with the interpretation placed by the High Court on various provisions of the Act. Reading section 23 with section 26 of the Act, it is clear that the award which is deemed to be a decree is the sum total of conclusions reached by the courts in determining compensation under section 23 of the Act on appreciation of the evidence between the parties. The costs under section 27 and the interest under section 28 and 34 are added to the compensation amount to make it a consolidated award. The cost and interest under the Act, if not awarded by the lower court, can always be awarded by the higher courts in any proceedings under the Act and to any party entitled to the same under the Act. Then kindly see the next page, para 18.
Last para.
My lord, we therefore partly allow the appeal and set aside the judgment of the High Court on the second point and direct that the appellant is entitled to interest on compensation amount for the period from so-and-so to so-and-so. The appellant shall further be entitled to 6% interest on the amount so determined from February till the date of payment. We make it clear that the appellant shall not be entitled to invoke the provisions of the amended Act for the purpose of claiming higher amount of interest or for any other claims. The appeal is allowed in the above terms with no orders as to costs. So this very decision does not award any costs in favor of the claimants. In fact, I was going through most of these other decisions. No cost was granted by any of the courts. Very rare cases. One of the cases where I found cost was granted is this decision, my lord. 2015, 2 SCC, 262.
Same page, the early one. This one was 262, this one was 262.
No, but this is 2015.
Yes, of course. I'm same page. The other one is.
So Lordships will have para 287. Para 50. It reads, by its judgment dated 24/12/2010, the High Court enhanced the compensation at the rate of 14,974, but the High Court had then awarded only costs of rupees 20,000. Thereafter, the appellants filed so-and-so inter alia contending that they ought to have been awarded entire costs at the rate of rupees 50,000 per square yard, enhanced compensation as claimed by the claimants. The appellant also claimed that the entire court fees of 48 lakhs affixed on the memo of appeal be included in the costs. The High Court rejected the plea of the appellant court fees and costs at the rate of enhanced compensation for the acquired land at rupees 50,000 per square yard as claimed by the appellants, but the High Court modified its order by awarding proportionate costs in favour of the appellants over and above the sum of rupees 20,000. The appellant party in person contended that they have paid court fees of rupees 48 lakhs and the High Court ignored the mandatory provisions of the law in awarding costs and that court fees is an integral part of costs. It was submitted that the impugned order dated so-and-so granting grant of proportionate cost is not in accordance with the well-settled principles of law. The appellant further contended that being partly successful before the High Court, they cannot be deprived of their claim of entire court fees and the costs. Then kindly see page 288, the second paragraph begins with the language of section 27. The language of section 27(1) is clear and very wide, and it gives power to the courts to order costs to be paid by what persons and in what proportions they are to be paid. In making order for costs under section 27(1), the court may have regard to the provisions of section 35 CPC. Analyzing such in 2 of section 27, it appears to consist of 3 parts. That is, when the award of the collector is not upheld, the cost shall ordinarily be paid by the collector as directed by the court. 2. The court is not bound to do so in every case. If the court forms an opinion that the claim of the claimant is extravagant or that he was so negligent in putting his case before the collector, then the court may make a different order as regard costs. And 3. The court may in such cases direct that some deductions be made from the costs of the claimants, or that he should pay a part of the collector's cost. Ordinarily, when a litigant succeeds in part and fails in part, the equitable order made is that he should receive proportionate costs. When considering his claim and so in exercise of its direction, the High Court rightly awarded proportionate costs and accordingly directed payment of such proportionate costs over and above Rs 20,000 as originally ordered. Merely because the appellants claimed compensation at the rate of 50,000 per square yard, the respondents cannot be saddled with the liability of paying the entire costs and the court fees paid by the appellants. There is no improper exercise of discretion by the High Court in awarding proportionate costs. Now kindly have section 27, which is there in this judgment itself, at para 53. I'll just read out the relevant provisions of this. So kindly see, it reads, every award shall also state the amount of costs incurred in the proceedings under this part and by what persons and in what proportions they are to be paid. So it talks about incurring costs under this part, which is part 3. That is during the reference proceedings, not thereafter. So in the reference proceedings, as far as I understand, there was no court fee involved. As far as these proceedings are concerned, Lordships are aware, they've all sued as indigent persons. They have already received 50% of the costs, 50% of the compensation. So as on today, they're not really indigent. They have not paid any court fee.
No, but they have made a submission that whatever court fee payable be adjusted against the, whatever final amounts given to them.
Lordship, if at all.
With regard to 2%.
If at all that arises.
Adjust the court fee.
Only 2.
So, Lordships will see, number 1.
No, but I thought it was all no.
No, Lordship, because here 46 people have filed the counter appeal.
The cross appeal.
Cross appeal. And 6 persons have filed individual appeal. Out of those 6, 2 persons have filed an application as an indigenous person. So that was allowed subject to the adjustment. Only 2%.
Okay. So then kindly see subsection 2 of section 27. This reads, when the award of the collector is not upheld,
yes,
the cost shall ordinarily be paid by the collector. So what is necessary is the payment of costs will arise only when the collector's award is not upheld. Now what's happened in this case is the court has pretty much upheld the award of the collector, but for the sake of achieving parity has granted uniform rates. Whatever rates they had paid for in their application under section 18 were rejected by the court. So strictly speaking, they did not succeed in upsetting the award of the collector. Collector's award was upheld. All those rates were upheld only for the purpose of parity. Uniform rates were granted. So my lords, I would respectfully submit there is no case for granting costs in this case. On the contrary, if Lordships look at our appeal, we have to some extent, I would humbly submit, succeeded in showing that there are a lot of problems and a lot of blunders in the calculations as well as the operative part of the judgments. There are a lot of problems. The courts have granted compensation, have granted solution on the entire compensation. There are multiple mistakes. It's replete with mistakes. Then, Lordship, a submission was made on behalf of my learned senior that, I apologize. Lordships had made an observation that since there is no proper determination of the market value, Lordships would examine the question of remand. My learned seniors oppose that. I equally also am not in favor of remand, because our case is very simple. Our case is that the principles of determination adopted by the court are not known to anybody. This is not a settled principle of law. Therefore, the court could not have granted any enhancement. And the judgments that I have referred to, they categorically lay down that the onus is entirely on the claimants. If the claimants fail to discharge the onus, the proceedings have to end there. The special court should not go any further, should not trouble itself to go into any further inquiry. So we would submit, my lords, that the court has fallen in some sort of error in going into further inquiry and granting uniform rates. It was not required to, because they failed to discharge their initial burden. So the question of remand, we are also equally opposing that. We would not be happy with remand, because that perhaps would give the claimants now an opportunity to bring additional evidence.
New handle.
Lordship. So it's not a case that we want to bring in evidence. We don't want to. There is no question about it, because the onus lies on the claimants. So if Lordships do remand the matter and give them the opportunity of bringing additional evidence, they might make their case better. Remand as well. And lastly, my lord, my learned senior made an emotional appeal that, considering the fact that they have gone through a treacherous, protracted litigation of 20 years, there should be a quietus to this litigation, and some amount should be determined by this court, and matter should be ended here. Now, I was looking at the case of Ranchod, which they had referred to. Something similar was done by the Honorable Supreme Court, which came to be interfered with by the Honorable Supreme by the High Court, which was interfered with by the Honorable Supreme Court. This is 2007 14 SCC 362. 2007 14 SCC 326. This is a judgment that they had relied upon.
Page number?
326. Union of India versus Ranchod.
We relied.
Yes. The relevant page is at page 328. Para 6, my lord. This reads, the landholders and also the Union of India preferred the appeals against the award of the reference court before the High Court. The High Court decided all the appeals by a common order, which is the subject matter of challenge in the present short order, and the relevant part of the judgment dealing with the controversies reproduced below. We would have very much liked to examine the merit of rival contentions, but it would serve the interests of none. It could only prolong the agony of petty landholders without resulting in the gain to union coffers. Assuming appeals filed by the union were to be allowed, it could prove futile because compensation amount awarded by the reference court stood paid or was in the process of being paid to landholders under the orders of this court with little or no prospects of its recovery. Similarly, if landholders' plea was to be entertained, it could entail remand to the reference court and protract the proceedings for years on to their disadvantage and detriment. Therefore, taking all this into consideration and giving regard to the interests of both parties, we deem it appropriate to end this litigation in let bygones be bygones spirit, because adverting to the issues raised by the parties would have opened Pandora's box, resulting in unending litigation causing avoidable hardship and inconvenience, more particularly to poor landholders who have reportedly gone through considerable suffering during the last 11 years for the sake of national defense. This is not to shy away from taking the adjudication to logical end, but to terminate the litigation to the mutual advantage and benefit of both sides. Learned counsel for both the sides have submitted that the High Court has not at all considered the evidence on record and has decided the appeals by a short and cryptic order, which shows a total non-application of mind. It has been submitted by learned counsel for the parties that the matter requires fresh consideration in the light of evidence which has been adduced by the parties. Section 54 of the Act, insofar as relevant for the purposes of the present appeals, says that subject to the provisions of the CPC applicable to appeals from original decrees and notwithstanding anything to the contrary in any enactment for the time being in force, an appeal shall only lie in any proceedings under the Act to the High Court from the award or any part of the award of the court. Order 41 CPC deals with appeals from original decrees. Order 41, Rule 31, lays down that the judgment of the in writing and shall state the points for determination, the decision thereon, the reasons for the decision, and where the where the decree appealed from is reversed or varied, the relief to which the appellant is entitled. This provision has come up for consideration on numerous occasions, and its meaning and scope has been explained. It is not necessary for us to refer to various decisions, but we will refer to one of the recent decisions, judgments given in so and so. The question whether in a particular case there has been substantial compliance with the provisions of Order 41 Rule 31 has to be determined on the nature of the judgment delivered in each case. Non-compliance with the provisions may not vitiate the judgment and make it wholly void, and may be ignored if there has been substantial compliance with it and the higher appellate court is in a position to ascertain the findings of the lower appellate court. It is no doubt desirable that the appellate court should comply with all the requirements of Order 41 Rule 31, but it is possible to make out from the judgment that there has been substantial compliance with the said requirements and that justice has not thereby suffered. That would be sufficient. Where the appellate court, having considered the entire evidence on record and discussed the same in detail, come to any conclusion and its findings are supported by reasons, even though the point has not been framed by the appellate court, there is substantial compliance with the provisions of Order 41 Rule 31, and the judgment is not in any manner vitiated by the absence of a point of determination. Where there is an honest endeavour on the part of the lower appellate court to consider the controversy between the parties, and there is a proper appraisement of the respective cases and weighing and balancing of the evidence, facts and the other considerations appearing on both sides is clearly manifest by the perusal of the judgment of the lower appellate court, it would be a valid judgment even though it does not contain the points of determination. The object of the rule in making it incumbent upon the appellate court to frame points for determination and to cite reasons for the decision is to focus attention of the court on the rival contentions which arise for determination, and also to prove his opportunity in understanding the ground upon which the decision is founded, with a view to enable them to know the basis of the decision, and if so considered appropriate and so advised, to avail the remedy of second appeal. In so-and-so case, an observation was made that it is not the duty of the appellate court, when it agrees with the view of the trial court on the evidence, either to restate the effect of the evidence or to reiterate the reasons given by the trial court. Expression of general agreement with the reasons given by the court, decision of which is under appeal, would ordinarily suffice. And it goes on to restate that same position. So here the court had interfered with the judgment of the Honorable High Court, where the court took the view that in order to end the misery of the parties, the court would determine a number and award it. So the court has interfered with that approach.
Yes.
And my lords, the last judgment is again a judgment from their compilation at page 171. Lords, in their compilation, Lordships will find the judgment at page 171. 1997, 6 SCC 41. The relevant page is at page 46 of the judgment. This is part of para 6. So at page 46 minutes, towards the end, at placetum E, it begins with even in the absence of oral evidence.
So you can cover your case of non-tendering any evidence by the collector.
No, this is on the issue of, just a moment, Melons. I think I've marked the wrong paragraph. Lord, placetum E itself, it begins with in the absence of oral evidence. Even in the absence of oral evidence adduced by the land acquisition officer or the beneficiaries, the judges are to draw from their experience the non-FID and genuine sale transactions are guiding star in evaluating the evidence. Misplaced sympathies or undue emphasis solely on the claimant's right to compensation would place heavy burden on the public exchequer, to which everyone contributes by direct or indirect taxes. So this is just to counter the last argument that was placed by my learned senior that a quietus should be put to the litigation by taking note of the sufferings that they've had for the last 20 years. Now, as far as the issue of cost is concerned, my lord, I think the judgments are fairly clear. What may be best is to avoid looking at the decrees, because the decrees have utterly computed, have made a very incorrect computation of what was awarded by the judgment. So, if your lordships just look at the judgment once, and I'll conclude with this, because I think there is some amount of, if you look at the decrees. So it would be best if we just look at the judgment to see where the court has gone wrong. Kindly have page 141. Paper book 1. At page 141, yes. Just that last part, because this is pretty much identical to most of the claimants.
Yes.
The claimant is therefore found entitled with 30% solatium per annum on enhanced compensation. So this is incorrect. It should only be market value per annum. So per annum has already been corrected by a supplementary order of the court. But as far as enhanced compensation is concerned, this is incorrect. It should only be market value. The next is, and with 12% interest per annum on the enhanced compensation with effect from the date of taking over. That is for the period of the first year from the date of taking over. This prescribed rate should only be 9%.
Yes.
9%. And as far as the subsequent period is concerned, 15% is fine. So that is the prescribed rate for the subsequent period. In addition, I'm also fairly conceding they are entitled to that 12% of additional compensation which is prescribed under section 23(1)(a). But that again, my lords, is only for, that is only to be applied on the market value and only for that period of 1 year, not to the entire compensation. So this interest here is governed by section 28, which the court grants. And all of this is to be done after adjusting the amount that has already been paid to all the claimants. So in the decrees that were drawn up, this was not looked into.
So now you say, as per the relief, all are the same. 30% solution.
By and large, by and large.
On the market, on the difference
So
of market
this
value.
solatium should only be on the market value, can't be on the total compensation.
Yes.
I think they are also in agreement with this. So this would bring down the award drastically. Number two, that 12% additional amount as contemplated under 23(1)(a), that is again only on the market value and only for the time period stipulated under 1(a). And the third is the prescribed rate of interest. So for that first period, it should be 9 instead of 12. And if your lordships will kindly have page 299
Paperbook.
of the same paperbook, page 299. This is in respect of claimant number 60, Rutsila Sinjri.
1 second.
Page 299.
Yes.
So here, if your lordships will see, the relevant portion is at page 302.
Yes. Yes. Reliefs.
Yes. So at page 302, these are the reliefs granted. Kindly see B. This is for the compensation of the balance area of 136 square meter.
Where are we reading from?
At page 302.
Yes.
Second paragraph, for the compensation of the balance area.
302.
302.
Yeah, okay.
This is in respect of claimant number 60. So it reads, for the compensation of the balance area of 136 square meter, which has become useless, the claimant number 6 total area of her 2 plots of land was 2016 square meters, out of which that the collector has acquired an area of 1880 square meters, and the rest of the land measuring 136 square meters has become useless and cannot be made use of, for which she is claiming compensation of the said area at rupees 4,000 per square meter, for which claim comes to a total amount of 5,44,000. So see the decision, Willows. However, no evidence on such severance nor the measurement of the land was proved by the claimant to the satisfaction of the court. But this court is also of the opinion that such severed land must be there, for no rebuttal came from the OP collector in this claim. Hence, for fair and just compensation of the same, this court awards claimant number 60 on such alleged severance 136 square meters by the same rate of wasteland at 50 per square meter. Court comes to the conclusion that there is no evidence whatsoever to the satisfaction of the court, but merely because there is no rebuttal. Why would a rebuttal be required if they have failed to discharge their initial burden? Court has applied a completely incorrect, unsound and perverse principle of evaluating evidence. So as I would just conclude with the following. Lordships will have to go by the settled position of law insofar as determination of compensation is concerned. And Lordships are in first appeal jurisdiction will examine the impugned order of the special court and see whether the court has adopted the known settled legal principles for determination of market value. If it hasn't, the matter would have to end there. The question of remand again is something I would most respectfully urge Lordships not to consider, because that would put them at an advantage. They might bring in additional evidence to prove an enhanced market rate. Lordships also see that the special court has applied a particular methodology which is not known, and therefore the entire determination stands vitiated. And assuming for a moment that Lordships agree and uphold the reasoning given by the court, that for the purpose of securing parity, the court was right in giving uniform rates and enhancing the rates, then I would most respectfully submit there is no need to consider their cross appeals, because there is no evidence on record for any further enhancement. So as per the settled position of law, in the absence of any evidence being brought in by the claimants, the question of giving any further enhancement cannot be considered, because our Lordships had observed the other day, what is the material before Lordships?
Yes.
My learned senior urged my Lords to consider it from your Lordship's personal experience. But how would your Lordships know what the price was and what it stood on the date of the Section 4 notification? We're not looking at the prices today. We're looking at the prices as they stood in the Section 4 notification on that date. And what was the material before the court? There is no material. There is no legally recognizable material which can be treated as evidence. And lastly, my Lords, as tempting it may be to consider the emotional appeal of the parties, the question still remains. The Lordships are acting in first appeal jurisdiction, and Lordships have to evaluate the matter strictly in accordance with law, and which is why I was related in Kura Sambasira, which says that misplaced sympathies cannot be a consideration for the court while dealing with the matter of determination of compensation. Obliged.
In fact, my learned friend has reopened the entire case, but I'll be very brief. First thing, Your Lordship, he has raised the question of jurisdiction, that inherent jurisdiction.
Yes.
Your Lordship, first of all, book one. First of all, no such ground has been taken in the memo of appeal, nor such a ground was taken before the trial court, before the reference court. And therefore, my first submission is this: he cannot urge that point now, which he has not taken before the reference court and even not included in the memo of appeal. Nevertheless, Your Lordship, Your Lordship will come to page 100. Which is a section 18 reference application. 100. Book 1.
Yes.
This is the prayer, Your Lordship. I have already read the entire petition. Here I will only go in the premises. It is therefore prayed that Your Honor would be pleased to make a reference to the Special Judicial Officer Meghalaya for determination of the actual measurement of the land, classification of the land, demarcation of the boundaries, market price of the land, and building, specifically mentioned, Your Lordship, building, standing crops, tree, cultivation, etc., and allow the landowner petitioner to withdraw the amount without prejudice as per the order dated so and so. Your Lordship, then I take to Your Lordship the page 107. The collector has referred this application section 18 to the Special Judicial Officer, last para. The application under section 18 of the Land Acquisition Act is therefore enclosed herewith for favor of kind necessary action and disposal at your end. For the purpose of disposal, and application is sent to the Special Judicial Officers. And it is incorrect to say that the Special Judicial Officer lacks jurisdiction in deciding other claims other than the fair market value of the land. Another point, Your Lordship, which my learned friend has been stressing time and again, that initial burden lies upon me. No quarrel on that point. I have discharged my initial burden by adducing the evidence of the landowners and also exhibiting 3 sale deed, calling the witnesses who were there or who have witnessed the execution of the sale deed, and the sale deeds are marked as exhibits. I have discharged the initial burden. Now, whether those evidence which are produced by me will be considered by the court or not, that question will come at the time when the court passes the order. There is no system like framing, first charge will be framed against me, that whatever evidence I adduce, whether a court will hear put a date for hearing on my evidence and then decide and then call upon the collector. This procedure is unknown. I have discharged my burden by examining myself and other similarly situated landowners who have stated that the market value, that the compensation assessed by the collector is not fair and as per the market value. I have adduced the evidence.
Yes.
And the moment I adduce the evidence, they seek time for adducing their evidence.
Never brought any evidence.
They never brought the evidence. That apart, Your Lordship, the court passes the order directing the collector to produce the copy of the original award as well as the related records. I have the copies of the order sheets which are written by Honorable Justice Dindo at the time when he was a special judicial officer, and there, Your Lordship, number of orders are there which are reflected. Just I'll give you, Lordship, full typed copy of the order. And there are other orders also which are typed, which I will read it from here. Your Lordship will say, will find that from the order rendered on 2005, the claimant is present through Shri V.K. Jindal, Senior Advocate, along with Srimati P. Sharma, Advocate, represented by H. Nongklau. Shri Jindal has submitted that in spite of the time given to the collector to file the relevant record, the same was not filed even today. Shri Jindal has further submitted that the claimant is not in a position to make a proper claim in the absence of detail like demarcation of the land acquired from the individual landowner, the rate given by the collector for such plot and other cited details. It was therefore prayed that the Chief Engineer PWD Road Meghalaya may be directed to cause measurement of the land acquired and to submit the report to this court. Shri H. Nongkla, on the other hand, has submitted that at least a week time may be given to the collector to supply the details. Having heard the parties going through the record, I am convinced that this matter has been prolonged enough time to the inaction of the collector. Accordingly, the Chief Engineer PWD Road Meghalaya Shillong is hereby directed to depute any competent officer to cause measurement of the land acquired for the and either side of the land as reflected in the notification. Let the Chief Engineer or his delegate properly demarcate the individual plot of the claimant and to furnish the report to this court for further direction or order. Your Lordship, from this order, Your Lordship will find that the collector has not done his initial duty. That is the physical measurement and the demarcation.
The next date, 13/7/2005, next date was 17/11/2006.
No, Lordship, only relevant order. I have typed, because order sheet is very lengthy, and 21 years order sheet contains number of pages. Then on 2006, Your Lordship will find that same thing is there. Claimant is represented, OP Collector Ibhai is also present. Al-Valing submitted that the detailed report on the demarcation and measurement of the land acquired vis-a-vis the land of the individual claimant has the court today. White petition number 7, the same may be accepted by this court. Measurement and demarcation was given to the court in 2006. It is not understood, Your Lordship, how the collector could make the award when he has not made the physical measurement and demarcation of the land. Reason being, Your Lordship, the road is going straight. Now, which side of the plot of the land it will touch?
Last time we submitted.
Last time I have already submitted, Your Lordship. So, in absence of that, under the facts, it was not possible on the part of the landowner to make the exact claim. because they do not know where the road is going, whether it will go this side or that side. Shri Jindal, as Jindal, learned counsel for the claimant, has however submitted that the petition number is so-and-so is filed, showing some discrepancy. The demarcation and measurement process by the concerned department, as such, this petition may be heard first before accepting the report of the collector. Shri Walang has prayed the time to file show cause. Your Lordship, next order which is relevant, the claimant is present, OP collector is also present. Your Lordship, as which I read it, is concerned, after they have filed this report of the measurement and the demarcation, there were still some discrepancies. And by application number so-and-so, 81906, I have brought this fact to the notice of the court. Then court passes the order on 2023-2007.
This is all the claimants, only one claimant.
All the claimants, not all, few claimants. Sri Adyan Learned Counsel has however submitted that the petition number is filed showing some discrepancy, the demarcation and measurement only for few persons, Your Lordship, which were mentioned in the petition, Your Lordship. Then, Your Lordship, Shri Sinkan, on the other hand, has submitted that the show cause could not be filed today as some necessary detail has not been received, and as such it was prayed that another date be fixed for filing of show cause. Upon hearing the parties and perusal of the said petition so-and-so, I have seen that the prayer of the claimant is with regard to the measurement of the land herein. This being a matter of evidence, I am of the opinion that the claimant can agitate this matter in the evidence for which no separate petition is required. Shri Jindal has fairly considered the issue of measurement of the land of the claimant acquired under the relevant government notification a matter of evidence and has submitted that evidence will be led in this regard. Upon hearing the learned counsel, let the claimant take steps for summon of the. Your Lordship, the court has come to the conclusion that it's all matter of evidence, and put the case for evidence. Then, Your Lordship, on 2011 also, order is passed, claimant present through counsel who files petition number so-and-so, seeking that the collector be directed to make available the copy of the award and all other related paper in this case, to which learned GP appearing for the collector submit the same will be made available on the next date. The claimant also seek issue of summons to the witness reflected in his list, petition number so-and-so with copy of the OP. Let summon be issued to the witness. Your Lordship, till 2011 they do not file. Then, Your Lordship, there are subsequent orders. I'll just type here, or I can just give. On 10/2/2012 also, collector is again directed to file the copy of the award and the relevant documents. 15/6/2012, 12/10/2012, then 24/3/2015, they are directed to file the copy of the award with the relevant records. They do not file, Your Lordship. Even the copy of the award, even in this court also, they do not bring the copy of the award. How they have?
But in this case, adduce more evidence if the claimants made a claim, then you would have easily got more enhancement then.
Yes, because they also agree it's a matter of evidence, and it was put on evidence, Your Lordship. Then, so Your Lordship, the repeated contention of my learned friend that the collector was not required to give evidence because I failed to prove my initial burden is not at all correct and sustainable. Now, my learned friend has also raised the point that the method adopted by the court, reference court, is unknown. Your Lordship, the court has to administer the justice. Now, the sale deed which were produced by me,
disregarded.
Court did not accept it for the reason already stated in the order. Collector was directed time and again to produce the record and the copy of the award.
Never came.
Then it never came. Under the facts and circumstances, what the learned court ought to have done.
Uniform rate.
Uniform rate as per the classifications. Because no justification was coming that why for a particular category of land, like homestead land, some people are getting 40 rupees, some are getting 80 rupees in the same village. No justification coming up. Court was well within its right and right to administer, to do the justice, to give uniform rate as per the classification made by the collector. Under the circumstances, there was no other things which was left out by the special judicial officer to follow. They have followed. Lordship. Now, your Lordship will find that I have also pointed out that the manner into which the execution acquisition proceedings were conducted is totally against the law and against the judgment of the Honorable High Court, direction contained in the judgment of the Honorable High Court. Despite that, they have not followed. Your Lordship, I have raised the objection under Section 4 notifications that we are not ready to part with our land. Without disposing that objection, Section 6 notification was issued. We have raised objection to that also. That was also not decided. Then, your Lordship, proceedings under Section 8 and 9 were not at all, proceedings under Section 8 were not conducted at all. That is, physical measurement and demarcation of the boundaries. Not conducted. Award was not made, and and we get only a notice that you come on so and so date and collect your this amount, which we have collected as per the order of the Honorable High Court, your Lordship. At least a copy of the award should have been made available to the perusal of the court. We have not been served with any copy of the award. These are, your Lordship, the admitted facts which are borne out to be true on the face of the record. And I would humbly pray to this Honorable Court to take note of this and pass necessary order, your Lordship. Now, this is a case, your Lordship, where collector do not file any written statement. He opt not to file. He does not produce the record despite the number of directions given by the court. And he does not produce any evidence. He says that initial burden lies upon the. I have adduced the evidence. Then it was for him to come. He said no. Those evidence were not sufficient. You have to file.
No, he's putting the entire burden on you. Now, see, the cutting short is that the terms of reference as per the arguments is that it is not clear and court exceeded jurisdiction in going into the other areas. Correct?
Yes.
Yes, that DC did not formulate. And then the fault lies in your application, But then, as you've shown in page 100, even though the praise small, it includes buildings also.
Yes.
That means the assertion that their buildings not mentioned has been mentioned.
No, but it's, in one of the independent appeals, there is fences, there's iron gate, none of this is
The
mentioned.
building includes
137 people file a short application without any details whatsoever.
Right, no, that's right. That's right.
And
We
we're only
noted
concerned.
that. We noted that.
Yes, madam.
We noted that. That's the only thing. Yes.
No, Your
Only
Lordship,
failing
Your
from what
Lordship,
the court can see, only
necessary
failing is
details.
that fine. It was not incumbent upon the Deputy Commissioner, in view of the reference had been made, to go by himself on his own accord to go and see exactly every plot of land and what terms of reference to be made.
Yes.
And so terms of reference as given lump sum in your application signed by 137 people was sent to the reference court.
Reference court.
And reference court decided whatever. But their case is that it can decide whatever. But the thing is that the subject to adequate, materials being placed and evidence being led.
Yes, Your Lordship.
Now it said that the onus is on you because the CLT is disregarded. You cannot produce any other supporting material with regard to the rates.
Yes, Lordship. Because sale deed will be rejected. That comes when the judgment is passed. Otherwise, I have no reason to believe that my evidence will not be accepted.
Apart from those, no other supporting materials were placed by you.
By my own evidence, 75 people have given the evidence.
No, I'm talking about this documentary evidence. Apart from 3 CLDs, nothing else was given.
Nothing else, Your Lordship. Nothing else. And whatever was there, that was with the collector.
And so even then the reference goes quite liberal in the sense that he said, okay, fine, for that once aim to give 160, give you 160.
Yes.
That is homestead land, arable land, cultivable land.
No fault can be found on the...
Only in the calculation part there's something wrong.
Calculation part, Your Lordship, arithmetical mistakes are there.
The calculation part has to
No,
be
Your
addressed
Lordship,
again.
as a matter of fact, on the last occasion also, we have submitted that in fact the decrees were not required to be prepared because the operating portion itself is a decree.
Yes.
Decree.
And the Act doesn't speak about decree at all.
And Act also does not speak specifically about decree. It's the award. These were made and lot of labor and exercise was undertaken by the staff, and mistakes are there. Calculating arithmetical mistakes are there. Now this happened because they were to prepare. They never prepared any such decree in the past, and mistakes are there. This is, I have already pointed out in a notice, Your Lordship.
Anything else?
Your Lordship, the collector, Your Lordship, has classified the land into 4 categories.
Yes.
Into 4 categories. That is homestead, arable, paddy field, and the wasteland. And the maximum rate which he has given for homestead 220, and for arable 160, and for paddy field 200, and for wasteland 50. These 4 rates.
Arable land how much?
Arable land he gave 160.
Oh yes, that's uniformly. Paddy
For paddy field land he gave 200, and for wasteland 50.
Okay.
Now, reference code maintained this classification as made by the collector, but took the maximum rate and
applied uniformly.
Applied uniform rate. And my submission is this: under the facts and circumstances,
It's
there
reasonable.
was no other way, and this apparently looks arbitrary. And arbitrary, if the award is, if the collector's award is arbitrary, the reference court is within its power to act according to the circumstances. Your Lordship, I have produced 3 sale deeds, and these are the customary sale deed. And now the question is this, Your Lordship, whether those customary sale deeds
Can be rejected.
can be rejected. If Your Lordship holds that the customary sale deeds are not admissible, then your lordship position will be, there will be quash, because this type of sale.
No, we can't give a general kind of finding. Every finding has to be on a case-to-case basis, under what circumstances the sale deed was executed, under what circumstances
No,
it was produced
no,
before the
your
court,
lordship, it will
under
have,
what circumstances it was proved. Then if we can't give a general declaration that we can't depend on custody. No,
yes,
it depends on circumstances itself.
circumstances.
Yes, if it's proved,
yes,
then fine.
Yes.
In this case, the way the sale deed was constructed, and maybe the court would let to believe that no, it's not reliable, so we're not relying on it. That's it. So that is the.
Let the court
will re-examine it. We'll re-examine. First appeal will re-examine it.
Your lordship will re-examine, keeping in mind, your lordship, that this type of practice is still there.
Of course, we cannot overlook that.
And because in the Garo Hills, specifically,
we can't accept it as gospel truth also.
And Pakka sale deeds are made on the basis of this. And here, these sale deeds, your lordship, are used only for the purpose of finding out the rate, and not for conferring any title over the property from buyer to seller or seller to buyer, whatever the case may be. Then, your lordship, there are 3 sale deeds, and if you take the aggregate of these 3 sale deeds, then aggregate comes, your lordship, 1544.97 per square meter. Per square meter. Now, the per square meter is the rate 1544, and per square feet will be 143. Your lordship, on the last question has pointed out, 143 will be less than 220, which I was telling.
Yes.
That here 220 is the per square meter. Here 143 is per square feet, and per square meter is 1544. Now, another thing, your lordship, that 50% deduction made by the special judicial officer is without any basis. We have brought the evidence, civil engineer who has given the valuation certificate, and which are not objected by the other sides, and he being the qualified person in his field, his assessment, your lordship, cannot be questioned, and when there is no other evidence brought. So, this 50% deduction which the court has made it should be restored back to the claimant, your lordship. Now, your lordship, latest judgment of July 2024 has come.
On what point?
Your lordship, on this when the sale deeds, your lordship, are not accepted,
We give citation.
yes, your lordship, this is a civil appeal number. Initial citation 2024.
SCC, yes.
No, individual citation.
No, I have a SCC. It's 2024. SCC online.
Yes.
SC 1691.
Your lordship, I'll give a copy. This is which is to be given. Just give the copy. Para 30 onward. At the time when I took out the print, it was not reported. It is July 2024. Para 30.
Para 31.
Para 30 on, let's see, para 30, Your Lordship. Consequently, given our analysis above, it is apparent that there exists no direct piece of evidence to determine fair and just compensation in the instant case. We must therefore resort to the settled principle of guesstimation. Then what is the applicability and use of the principle of guesstimations? Guesstimation is a heuristic device that enables the court, in the absence of direct evidence and relevant sale exemplar, to make a reasonable and informed guess or estimation of the market value of the land under and concomitantly the compensation payable by the appropriate government. In that sense, guesstimation hinges on the court's ability. Indeed, this holds true for valuation of the land in general, which is affected by a multitude of factors such as its location, surrounding market conditions, feasibility, user, etc. Accordingly, while evidence calculation can aid in estimating the land value, they ultimately serve as tools for approximations rather than precisions. Instead, land valuation and consequently the fixation of compensation remains in exercise of informed estimations, requiring the integration of diverse data points and professional judgment concerning subjective, intangible and dynamic elements. Pursuing a single precise valuation or compensation figure is bound to be unjust and a procrastinating endeavor at best. Having said that, it is important to clarify that the process of determining compensation is not entirely subjective. While it may not be possible to arrive at a definitive figure, the exercise is still epistemologically objective insofar as it is grounded in evidence and the consideration of relevant factors. In case the compensation is fixed agnostically to the factors affecting the valuation of the land, the resultant figure might be arbitrary and may fail to adequately compensate the landowner for the expropriated land. Hence, while some subjective may exist in fixing the final figure based on these factors, the sliding scale of judicial discretions cannot be extended to mere speculations. Accordingly, can use the principle of guesstimation in reasonable estimating the value of the land. In the absence of direct evidence, the exercise ought not to be purely hypothetical. Instead, the court must embrace a holistic view and consider all relevant factors and existing evidence, if not directly comparable, to arrive at a fair determination of compensations. In so summarizes, it will be appropriate for us to state certain principles controlling the application of guesstimate. Produced by the parties is not sufficient to determine the compensation with exactitude. This principle can be resorted to. Discretion of the court in applying guesswork to the facts of a given case is not unfettered but has to be reasonable and should have a connection to the data on record produced by the party by way of evidence. Further, this entire exercise has to be within the limitations specified under section 23 and 24 of the Act and cannot be made a detriment thereto.
We now to meet the characteristics, I mean the broad definitions, potentiality, characteristics, and
broadly, such relevant factor can be divided into three categories: characteristic of the land, future potentiality of the land, these things. And thirdly, factors denoting market sentiments. I'll just read. Market sentiments are powerful drivers of land valuation. Even if a particular piece of land possesses all desirable features, its valuation can still suffer if the market condition at the time of publication of the notification under section 4 of the 18 were unfavorable. Factors such as economic recessions, political instability, speculative investment or real estate crisis can impact the perceived value of the land. Thus, these extraneous economic and political factors must also be considered when assessing land valuation. In the instant case, evidence led by the parties provides several relevant factors as enumerated above. For instance, while the sale deed produced by the landowner cannot be directly relied upon for determining the price of the land given its relative proximity, it nonetheless is in the form of possible use towards residential purposes. Likewise, the lease deed further underscored the commercial potentiality of the land in adjoining vicinity, as Sector 18 is situated only 3-4 km away from. As in the case of Sector 18, the acquired land is well connected to major road and has adequate supply of water and electricity. Further, as highlighted by the landowner, the land under acquisition lies near prominent amenities and landmarks such as Army Public School, a large government tourist attraction. Apart from that, it is also in proximity to the DSC Shade Club. Then additionally, the acquired land is evolved by developed colonies and market on all three sides. Toward the western periphery, it is bordered by NT road. Here are these things they give. I come to para 39. More importantly, the land is not uneven, prone to the flooding or subject to construction restriction. Taken together, all these facts and evidence lead to the reasonable inference that the subject land had significant potential for future commercial development at the time of issuance of the notification under section 4, akin to the development witnessed in the lease deed for Sector 18 Noda. At this juncture, we may clarify that the mere absence of multiple sale example also does not by itself support a conclusion that the market condition was unfavorable or the land had and low value.
Okay, we understand this, yes.
Yeah, Lordship here, in this case, the para 42, your Lordship, only one para.
Yes, I've seen that, yes.
Para 42, how they have resolved this thing.
Quantum, yes.
Regarding the quantum of compensation acquired land, and escalation is merited even if we were to rely on the lower end of the rate fixed by NODA itself. So 15% escalation for 1 year to this price they have given.
But how far is this formula guesstimate?
Sir?
It is not based on any,
Your Lordship, here at the end of my argument,
Supreme Court
on the
can
last
say
occasion,
this guesstimate, but if we say guesstimate,
Your Lordship will apply your own experience or own thinking process that here aggregate value of the land in by taking 3 sales into consideration comes 1544. In the case which I was reading, 15% escalation is considered.
It was 1 year to this price being
Yes,
automatically.
15% escalation is considered. In this case, instead of escalation, your lordship may consider that no, this is on the higher side. This is on the higher side. And cut short the same, what your lordship will feel or come to the conclusion that this should be the value of the land. Now, escalation may not be, and 1544, whatever, last time I was telling, even if your lordship take 50% of this and work out the compensation on that basis by the estimations. Here, my purpose of bringing this judgment is to say that your lordship has, when the sale deeds are totally not acceptable, then your lordship will use
another way.
Another way to look into the issue posed under the facts and circumstances of the case. And lastly, your lordship, I have also stated that if this also does not please to your lordship, or one or the other reason, then your lordship, the maximum rate of the homestead land is given 220 per square meter.
Yes.
Per square meter. Now, I have already shown to your lordship that when a land is acquired for a particular purpose, more particularly for construction of road, the classification is immaterial. So, that is the last thing which your lordship can at least do, but I will impress upon this court that this court, by following the principles of guesstimations, will work out the rate on the basis of the 3 sale deed which we have produced it and which were not objected by the, and the collector, though he might have some evidence, has failed to bring any evidence. With regard to your lordship, my learned friend has already agreed that I am entitled for additional amount under section 23(1)(a), and statutory interest for 1 year 9%, and for subsequent year under section 28 read with 34 it is 15%. After expiry of 1 year.
1 year.
1 year. With regard to your lordship cost is your lordship will see according to the discretion of this honorable court.
Come back to cost.
Cost.
What is the submission on cost?
Cost, your lordship, my submission is this, your lordship. The contention of my learned friend, one way he says that the court has not interfered with the award.
Yes.
With the award, and has accepted the maximum compensation which the collector has given. This is not correct, your lordship, because the maximum compensation is given to the few selected persons, not to the all, not to the all. So, submission of my learned friend that reference court has not done away with the award of the collector is not at all correct. The reference court ought to have awarded the cost, your lordship. And your lordship will look into the facts and circumstances of this case, the manner into which this case has been conducted by the collector, and for his negligence and inaction to actively participate, not to speak about actively, not to participate at all, just appoint, ask the government advocate to appear, Nothing more than that has been done. Taking all these things into considerations. And earlier the special judicial officer used to sit in Shillong, Your Lordship. Right from that area, they used to come for reducing evidence, incurring cost to Your Lordship, and cost of filing reference, cost of filing petitions, witnesses, getting it assessed.
Okay.
Then. So,
Yes.
I'm entitled for cost to Your Lordship, which Your Lordship may deem fit and proper under the facts and circumstances, Your Lordship. That is, Your Lordship, my submission.
Just
otherwise, it will not end.
I'm done with it. Just two
Otherwise,
clarifications, Vinod. Just two clarifications. One is on the question of inherent jurisdiction. I have not raised this point in my appeal. I have shown lots from the judgment of Pragyag Upnivesh. Similar thing had happened, that the collector did not raise that point. The Honorable Supreme Court held that's a question relating to inherent jurisdiction. It can be raised even at the end stage in the SLP. On the question of that 50% deduction, that was the discretion of the court. If Your Lordships will just have that additional paper book which was filed by the claimants, there are some unexplained costs. I will leave it to Your Lordships to examine it. The additional paper book. Kindly have page 76. If Your Lordships have it, page 76.
Yes.
Kindly see rate per quintal. There is an entry there. This is the assessment which has been prepared. So there is market rate. Then serial number 2 is labor at 25%, contingency at 3%. They're asking for losses and they put in labor charge and contingency fee. None of this is explained. So this was the discretion of the court to accept how much is to be granted, and the court has exercised jurisdiction, has exercised its discretion. And lastly, this judgment of New Oak, I've already gone through the judgment. Please also examine para 25 and 26. My learned senior has said that in this judgment there was no evidence at all, and therefore the court resorted to the principle of guesstimation. If Your Lordships will see para 25, there has to be a foundation. So it reads, however, utilizing these sale deeds as the foundation for determining compensation, it is imperative that these sale deeds satisfy certain criteria of comparability. In this regard, it is necessary that the sale deeds adhere to the following factors. Sale deed must be genuine transaction. The sale deeds must have been executed at the time proximate to the date of notification. The land covered by the sale deed must be in the vicinity of the acquired land, and the nature of such land, including its size, must be similar to the acquired land. Adverting to the facts of the case in hand, it is germane to our analysis to note that the landowners have placed their reliance only on one sale deed dated 22 to 1989. And then can you see para 34? Para 34 reads, accordingly, while the court can use the principle of guesstimation in reasonably estimating the value of the land in absence of direct evidence, the exercise ought not to be purely hypothetical. Instead, the court must embrace a holistic view and consider all relevant factors and existing evidence, even if not directly comparable. And then kindly see, they refer to the judgment of Trishala Jain versus State of Uttaranchal, and in that same subparagraph, kindly see A, wherever the evidence produced by the parties is not sufficient. So there has to be some basis of evidence. There has to be evidence and there has to be data on record. So even in B, it says discretion of court in applying guesswork to the facts of a given case is not unfettered, but has to be reasonable and should have a connection to the data on record produced by the parties by way of evidence. And lastly, para 36. It reads, in the instant case, the evidence led by the parties provides several relevant factors as enumerated above. For instance, while the sale deed produced by the landowners cannot directly be relied upon for determining the price of the land, given its relative proximity, it nonetheless establishes its potentiality in the form of possible use towards residential purposes. So, in this case, in the facts of this case, Lordship will go through it. There was evidence on record, but it was not sufficient evidence, and therefore the court resorted to the exercise of guesstimation. That's all. Highly obliged. By sometime at the end of the week, we'll make a compilation of our judgments and we'll place it.
When you have to, even on the point that you argued, you give these points, no? In this.
So we'll make short bullet points, well, others if it's a long-ranging...
Don't make long-ranging arguments. Just make bullet points, yes. Especially on points of law.
Yes.
And yes.
Obligement.
Hearing concluded, judgment reserved. No, hearing concluded. Parties submit compilation of judgments and also bullet points of the arguments by
next week, by next Monday.
By
Right.
29th.
Compilation I have submitted.
By 30th, no? 30th.
Item 30.
My Lord, here on the last occasion, Lordship has put a query with regard to the last document that was enclosed in the affidavit in opposition by the state. So, my Lord, we have received our instruction, my Lord. If Lordship wants to, even the original file of the department has also been requested to be produced. What happened here, my Lord? The complaint letter, my Lord, was addressed to the Chief Secretary, my Lord, to the office. So thereafter, it was...
1 second, huh?
My Lord.
Where's the affidavit?
My Lord, affidavit dated 16 November 2023 of the state, my Lord.
Page 33.
Page 33?
Yes.
33, my Lord, Annexure 11. Lordship has put a question, there is no signatory in this particular reply, my Lord. So, my Lord, what have happened here is that this was in response to the complaint letter, which is part of the writ, dated 30th November 2022. A complaint letter was written by the petitioner to the office of the Chief Secretary, my Lord. And thereafter...
Who made the report?
My Lord, this complaint letter was written by Mr. Wilkinson Sutting, petition number 1.
By whom?
My Lord, it was addressed to Chief Secretary, my Lord.
Who made the report? Who made the report?
My Lord, that is what, my Lord. So thereafter, my Lord, the letter was submitted and it was subsequently assigned to the department to respond, my Lord. So thereafter, my Lord, these are the corresponding letters, and pursuant to which this particular reply, along with a letter which we have inadvertently did not enclose, my Lord, here, they have submitted to the office of Chief Secretary. However, Chief Secretary did not pass any orders in the light of the fact that there is sub judice in this honorable court, my Lord. We have a copy of the entire set, my Lord, which was... My Lord, the first letter is the complaint letter, which is part of the writ. The second letter is the matter being assigned to the concerned department. This concerned department, my Lord. So they have even asked to hold a meeting with the concerned department, and the subsequent letters is the proceeding of the meeting. And thereafter, my Lord, we'll see...
Whose documents are these?
My Lord, this is the proceeding of the meeting pursuant to the complaint letter.
Who chaired them in registrar?
My Lord. Lordship may kindly come to the letters before the horizontal paper which I have given, my Lord. That is letter dated 26 May. So, my Lord, thereafter meeting was conducted. This report was submitted to Chief Secretary's office. However, the writ was pending before Honorable High Court. That's why, my Lord, the Chief Secretary office perhaps did not pass an order. They're waiting for the disposal of this matter, if at all, my Lord. And moreover, the petitioner has never prayed for disposal of the writ. They wanted to be heard. So at the very beginning also, we make a proposal, why not we be allowed to dispose of. But he was insisting the matter to be heard.
The report has gone...
We are not aware of all this order, Your Lordship. Because we are not aware of this order also. When we file a complaint, they have not issued notice to us also.
My Lord, it was part of the affidavit. It was filed very early.
Just now received a copy, Your Lordship.
My Lord, the petition was filed on 16 June. So thereafter, my Lord, the same year we have filed our affidavit. It was part of the, my Lord.
But then the thing is that that was not filed on 16 June.
Our counter affidavit was filed in November, my Lord. So they were always in part of the proceeding, my Lord, which they have conceded also.
So they concealed that.
My Lord, we kindly have the proceeding of the meeting, my Lord.
The thing is that, see, the thing is that, Mr. Majal, you see these documents they produced. When do you file this writ petition?
I filed it once.
My Lord, as per our record, is 16 June 2023.
16 June 23, okay. Yes, now, they started proceedings on 16 May 23, and proceedings were held, and this is 10/1/22, okay, then 24, okay, forget, these are old letters.
26 May, my Lord, this report was prepared and submitted to the office of the day.
So, see, shareholders have given written statements since 22 also. Is you not aware of this?
No, Your Lordship.
That too we cannot question, my Lord, whether they were aware or they are
because after lodging a complaint, we are not aware of all the inter-department communications. We never communicated.
What about the statement filed by the members of the shareholders? This is filed by, this is by you only, this letter, 21st February.
My Lord, there is a name.
You know where this letter?
His name is there, my Lord, at the bottom.
Okay, so anyway, then says that.
No, Your Lordship.
See, now you filed this representation also. This is 22.
Yes,
right. And this is the last part. In conclusion, members, shareholders of so-and-so, by the office as registered to examine the matter to safety and safeguarding the rights. Okay, fine. Then, on your complaint, this report generated.
My Lord.
You take instructions from your client.
Yes, I'll take instructions.
With regard to what proceedings did they attend them at all?
Yes, Your Lordship. Okay.
Before the report generated. Yes, pursuant to the order dated, last order was 9/7/2024. MS Arconi, GA for Responder 125, has produced a set of papers which include complaint filed on representative before the Chief Secretary and a report which was furnished by the Registrar of Corporate Societies, which includes some proceedings. Mr. Majao submits that he may be allowed to obtain instructions on the said documents. This when?
2 weeks, Your Lordship.
This after 2 weeks, yes.
Hurry up, my Lordship.
44.
Copies of the documents are taken on board. Okay.
Lordship, as per the order of 28 June, I am required to file this application to implead respondent number 3 to 10, Your Lordship. And here is the petition.
You have filed it through the court to registry?
I went this morning, but...
no, you can't file it here.
Then I'll file there, Your Lordship.
What is the meaning of this? It's not a trial court that he'll register it here. It's yet that placing out 1 week further time to file upload application. Praise allowed. Yes. Should have filed it just now. They could have been brought to court. Yes.
Your Lordship.
47.
Who filed it?
My Lord, in this matter, in trial court, the matter will be fixed on the 6 August 2022. The matter in the trial court title suit will be fixed on the August 2024. And what happened there, I have already filed one application order 7 rule 11. So let the court pass an order first there, then I'll inform this.
Mr. Khanong, where's the petitioner?
She was here just now.
Mr. Khanong submits that as the matter before the trial court is fixed on 6 August, he pays that the matter listed.
Yes.
Thereafter, this matter up to 6 weeks. Yes?
I'll do that.